Welcome, BUL 3130 students. This will be the lecture for Chapter 1. This week, the only lecture we'll have will be Chapter 1. Chapter 2, you'll read on your own. I just lecture on Chapter 1. I don't normally lecture on Chapter 2. You can read it, go over the information in it, and you'll be plenty prepared for the quiz for these two chapters. All right, so I want to share the PowerPoint with you that I'll be going over. All right, here we are. Everything out of the way. All right, so nothing is blocking your view. All right, so we're going to do an introduction to law. Now, any class you take, doesn't matter, law class that is, you're going to have normally some type of introduction to law. This is business law that we're doing, but in business law, knowing some of the basics of law, where it comes from, is helpful in what we do. So we'll talk about the nature of law, how law is classified, some of the sources where law comes from, and we'll go do look at a little bit of legal analysis when we go through this. So law, when it's defined, depending on where it comes from, this definition is out of Blackstone's Law Dictionary, which is a very exhaustive law dictionary, exhaustive, however you want to look at it. But it's exhaustive and it covers pretty much all the terms and everything that you do with law. But it's a rule of civil conduct prescribed by the supreme power in the state. We'll talk about what that is, commanding what is right and prohibiting what is wrong. And that's law in general and how law is set up. All right, so if law is doing how it should, we have our law set up and our society is following the laws in the way that it should. All of our leaders and all those who are tasked with preserving the law and keeping everything straight, and all the citizens are doing as they should. This is what law is meant to do. Maintain stability in our society, our political and our economic systems through a dispute resolution, giving parties a chance to resolve any disputes they have about what is going on. Protect the property of others and the preservation of the state, while simultaneously permitting some type of ordered change when things change, or when we have a change in administrations, a change in leadership, however that may be. Law maintains and government maintains the law and order by legal sanctions. They will place some type of legal sanction. Those can be fines. Those can be that can be imprisonment. It can be both, right? So fines and imprisonment are normally how things are handled through law. When we talk about civil, it's going to be compensation that parties owe each other, some type of duty that's owed to another party that the court will enforce the payment of. Law goes into a lot of different areas and allows us in business to have a good business relationship with others, allows us to continue to operate our businesses as long as we're doing everything legally we should, and we know how to operate a business. Law is not going to come in and run it for you if you just do not know how to run it, but it's going to give you all the tools to be able to run a legal business and do so. And if you have to look for some type of compensation, or someone has harmed you, you have a way to have that remedied and be made whole. Well, we run into some issue sometimes is what we look at with our laws and morals. Now, we all have a moral compass of some sort. We have some something we're taught, how we're raised, if we follow a religious teaching. Those type of things are what we look at as our morals and how our morals are set up. Those are not the same as laws. So even though our morals may very well mirror most of our laws, if it's a religious teaching that tells you not to kill, not to steal, those type of things. There are laws that also say that you do not kill someone unless there's extenuating circumstances such as self-defense or you're in a state of war and you're in the military. There are laws that say you do not steal from others. All of those will come with some type of sanction, a legal sanction that is brought against you. To where on the moral side, it's the sanctions of yourself and how you react. If we, do not have the proper morals and we treat people in ways that we shouldn't treat them, well, society itself will take care of the sanctions against us, normally with a loss of friends, a loss of status. And if you're in business and you do those things, you'll lose business and you'll not be able to run your business in the proper way or be able to maintain your business in the way that you would like to. Law and justice, even though we think they should be the same thing, are not always exactly the same. Law and justice are separate, distinct concepts. Justice is fair. If something is just, it is fair, is how we look at it. It's equitable, it's impartial, it's treatment of competing interests with due regard for the common good. That is what justice is. Law doesn't always seem to follow that to the fullest extent. Any one of us can probably point to something in the law that we think is not just, or something that we think is not fair, or that works better for you than it does for me. That is where justice and laws diverge. We think of justice, we think that whatever justice for you is should be justice for me. Laws, on the other hand, we look at those sometimes and we say, okay, well, that gives treatment to this group different than it does to this group. And so law in and of itself, even though it's designed for all those things, like keeping a a society that follows an orderly way of doing things, it may not necessarily be that way. This is a good little Venn diagram that kind of shows that. Your law tells us we must drive on the right side of the road over here. The morals say that you should not silently stand by and watch a blind man walk off a cliff. There's not a law that says that you have to assist this person, but our morals, for most of us, would say, well, you don't do that. If you are tying your morals into a religious teaching in some way, it's probably going to overlap. Thou shalt not kill, you shall not kill, one of the commandments in a Judeo-Christian religious teaching. That combines a law that we use and a moral that we use. Most of us would not morally think it is okay to just kill somebody. The law says it is not okay to just kill somebody. That teaching says it is not okay. Sometimes they do overlap, but it's not always the case. The classification of law, and when we think of what classifications of law are, there are several that we'll go over. Substantive and procedural law are the two that we look at. The way I like to describe these, and probably the best way I've found to describe them where they make sense, procedural and substantive are different parts of how the law is set up. So if you think about you're cooking a cake, the recipe calls for you to have flour, sugar, milk, eggs, whatever else. All right. The recipe will tell you how much of each you need, how much to put in, when to put them in when you're mixing it, how long, once you have all those ingredients together, you are to place them in whatever device you're using to cook, and at what point you should check it and see if it is done. The recipe will tell you all those things. That is procedural, the procedure you follow to get to a point. Procedural part of law, procedural law tells us this is how the law is supposed to work and what we're supposed to do within the law to get to a certain point. Now, substantive is what is in that law. So procedural is the process of getting to a cake. Substantive is the cake. So when we're looking at substantive law, it is the law creating rights and duties. What is inside of this? What do we get when the procedure is followed properly. If the procedure is followed in the way it should legally, when we think about law, if the procedure is followed in the way that it should, we are protected against uh, cruel and unusual punishment. We're protected against testifying against ourselves, saying anything that would incriminate us. We're protected from an illegal search or seizure of our property, of our vehicles, whatever it may be. We have those protections. We all think about the protection of freedom of speech, freedom of religion, those type of things. Those are the rights that were given. And as long as the procedure is done properly, all those stay intact. It's when the procedure is not done, the procedural part of law is not done in the way it should be, that the substantive side cannot work and it breaks loose from how it should be. And then we have to look and see what is going on with the law. That is substantive and procedural, the same way that if you're looking at a recipe for a cake and it says you put in 2 eggs, uh, a tablespoon of butter, the flour, 2 cups, whatever, and a cup of milk. However, you put in 3 cups of milk, you're probably going to turn out a cake that is going to be more the consistency of a pudding than a cake because it's going to be too moist. All right, it's going to be too much liquid within that for it to cook off. Or you're going to have to cook it to the point that everything around it's going to turn to crispy, crusty nothingness that you do not want. If procedure is not followed and laws are not done in the way and enforced in the way they should be, then what's left over is something that society does not want, we do not want. So the procedure has to be there for the substantive side to be what we need it to be. We then have public and private laws. Public laws are those that deal with the relationship between government and individuals. Public law, we all see, we all know. We are a rule of law system in our nation. The United States is a rule of law system. Each individual has the right to look at the rules. You can go on the Florida Senate page and see the statutes. You can go on the governmental pages for the United States government and see statutes and laws that Congress has passed. You can see all of that. It's all written down. You can go onto the Constitution's website, open up the Constitution, see the Bill of Rights, see everything that is entitled or encompassed within the Constitution and all the amendments that have been added to it. You can see all that. We have access to it. There are not any hidden laws. They're out there. We may not know to look for them in certain circumstances, but the laws are where we can see them. That is the basis of a rule of law system. We can see the laws. Private law, on the other hand, is what you have amongst a group of individuals. In a classroom setting, you have the rules of the classroom. You probably did this when you were in kindergarten, first grade, those type of things. The teachers would post the rules of the classroom. When I taught high school, we had those to a certain extent in the classrooms just because there were certain rules that had to be followed. Hats off in class, no cell phones, those type of things. Those are all rules that pertain to the school as a whole or the rooms in general. If we get a group of people together, say it was in a classroom setting where we're in there and we're learning this material in the classroom and we decide on a set of rules, we would probably have things like you do not speak when someone else is speaking. Any conversation should be civil, should not be arguments or any disrespectful way of speaking to each other. I don't feel there's a need for that in society. We have too much of it. We see it too much. Um, the rules may be that if you leave the room, do so in a quiet manner so as not to draw attention away from whoever's speaking at the time, those type of things. Those would be rules that would apply to just that group, but not the group next door. So if there was a classroom right next to the classroom we were in, they may not have the same exact rules. They may all talk at once. It may be a classroom that's based in chaos and how the material they're learning is done. So they may all do that. That's the difference in public and private law. Then we have how the laws are classified into civil or criminal. And we'll talk about both of these throughout this term. We'll spend some time talking about criminal and civil. Civil is the rights and duties that individuals owe each other or businesses owe individuals, individuals owe businesses. It's one legal entity owes it to another legal entity. In civil is when we take care of any wrongs that have been done against individuals or against businesses and those type of things that do not quite always meet the realm of criminal law. Civil law is where we have compensation as the punishment. At times, you have damages that are assessed. And some of those are compensatory damages, some of those are punitive damages. We'll talk more in detail about that when we get to civil law. But that is how the sanctions are handled in that part of law. On the criminal side, we already touched on that's your fines, your incarcerations, those type of things. That is criminal. If they're violated, they constitute a wrong that's done against everyone because those laws are made for everyone to follow. So if we all have to follow the law, we all have to do exactly what the law says. If any one person diverges from that, they have not only wronged that law, they're wronging all of us because they've now put themselves beyond us or above us as society. So they've said that I don't have to do everything that society is doing. I don't have to follow the law. And then we handle that in criminal courts, where they will be tried and by a jury of their peers. They have all the rights that come with that are given to it, which we'll discuss when we get to that criminal law section. Some differences in civil and criminal, and these are just real quick. I'll go over those. The biggest of these is burden of proof. Uh, Criminal law is a lot harder to prove because it's beyond a reasonable doubt. Beyond a reasonable doubt, uh, a lot of ways of thinking of it, a lot of things you look at will be a person is 97.5% sure somewhere in there that the outcome is what they think it is. If it's guilt or innocence, they're 97.5% sure, something above that, that a person is guilty. That's beyond a reasonable doubt. Preponderance of the evidence is just believing one side a little bit more than the other, enough that you would award them for damages that they incurred. The outcomes are guilt and innocence, or guilty and not guilty in criminal. In civil, we call it liable or not liable. The principal sanctions are monetary damages and equitable remedies for civil. Criminal is going to be the punishment, imprisonment, and fines. The cases are brought in civil law by the aggrieved party. The plaintiff sues a defendant. In criminal law, the state or federal government is the one that brings those cases. I've heard all my life people say it all the time. I'm going to press charges on you. Well, actually, the state will be the one pressing the charges. You may just ask them to do it. So it goes through the criminal side, and the state or government, whatever the government may be, will be the one bringing the charges. So the sources of law that we have: constitutional law, that is our fundamental law and also our highest law in the land. So any law that is passed, anything that comes out from an administrative agency, anything that comes from any type of governmental entity, it has to be weighed against the Constitution. Does it violate any constitutional right that is given to individuals? If it does, then it cannot stand as a law. That's the reason you hear cases going to the Supreme Court, cases going to these appellate courts, the Fifth Circuit, the 11th Circuit, which we're part of here in Florida. It goes to all these federal circuits, and it's a question of, is it constitutional? Does it violate a right that individuals have? And they do that by looking at the Constitution and weighing it against it. Federalism, which is what our system is called, is when we have a division of government. We have a federal government and we have a state government. They work together, but also independent of each other. Your states technically work independent of your federal government. We have state laws. We have an executive in the state, that is our governor and the governor's cabinet. We have a legislator in the state, that is our Senate. In the state of Florida, is the Senate and House of Representatives. Then we have a judicial system. In the state of Florida, we have a Supreme Court. We have the appellate courts that fall up under it. Then we have our circuit courts, which are where criminal laws are handled. Then we have county courts. So we have a full system. That system is mirrored within our federal government, where we have all those things also. We have an executive branch, we have a legislative branch, we have the judicial branch, all the pieces that we have in the states. So they mirror each other to a certain extent, but they're also separate. If the Constitution does not give a specific authority to the federal government, then it is given to the states. If it's not granted to the government, then the states retain that power. There are certain things that will go to trial every once in a while that states will do. And the question that's being asked is this the federal government's job or is it the state's job to enforce this type of law on the citizens? States will sue the federal government because they believe the government has overstepped its bounds. At any given point, there are, 10, 30, 40, 50, 100 lawsuits going of states suing the United States government because they believe that they've overstepped their bounds in some way. That is how the states handle grievances against it. They take it to that. Those end up at some point, normally with the Supreme Court. Judicial law is based on common law. It's a body of law developed by the courts, and equity is based upon principles distinct from common law and providing remedies not available at law. If it's developed by the courts, then it's not quite the same as what we have with our legislative. Equitable law is a body of law based upon principles distinct that provide those remedies that are not available at law. So those definitions kind of got blended there, but common law is developed by the courts. When the courts make a ruling, it becomes common law. So when we hear the Supreme Court make a ruling and they look at precedent or they look at whatever it may be and they say, we're going to rule this way, that becomes common law. Many times the Supreme Court will just stick with what's there. Sometimes they will decide that, well, that was interpreted wrong by this court, so we need to look at it in this way, and they may change it. Then that becomes the common law. It's common amongst all people. Our legal systems are set up based upon what English common law tradition was and how our Constitution says they have to be set up. The common law legal system is adversarial. In the United States, we have an adversarial legal system because we have two sides that argue a case in front of a jury or a judge. In other places, you may have a tribunal court, which is the judges asking the questions of the witnesses and those things. So that is where you may have a difference in that. We have precedents where a lot of our judicial findings are based. Courts look at what was done before, what was decided before, and they will normally go with that. That is some authority that's then moves forward. Once precedent is set, it becomes an authority that moves forward through the court system. That a big part of that and where things were changed and how we look at that is Brown v. Board of Education of Topeka, Kansas. Most people have heard of Brown v. Board. Brown v. Board was the case in 1954. The justices unanimously ruled that racial segregation of children in public schools is unconstitutional. Not something you see much anymore, the word unanimous with the Supreme Court. That's a sidebar, nothing to do with what we're talking about here, but you don't see that much anymore. But the justices were unanimous in their decision that racial segregation was not constitutional. It was a cornerstone for the civil rights movement to help establish a precedent of separate but equal. That was not, in fact, true. So up to that point, it was separate but equal. That children that went to schools that were predominantly for white children and children that went to schools that were predominantly for black children, the law at the time said they were separate, but they were getting equal teaching. Well, it may not have been so. And the court said, well, that's not so. And the court said, this is not right what you're doing by separating them and giving this group the best books, the best uh, facilities, giving them all the best stuff while this one is scrounging for materials. So separate but equal was not working. The court said, no, this is not right. And they changed it, and it became, this was 1954. I can remember in my childhood, and keep in mind, I was born in the 70s. I can remember in my childhood, there were still cases being fought in court based upon this that had to do with busing of students and things along those lines. My mother, who graduated high school in 1972, went to schools that were segregated in our home county up until the 60s. Our county was not fully separated up until a later time. Just because it went in 54, it took a while, and we were not the last to desegregate. So those things were happening. Sometimes when cases come out and the judges, the justices of the Supreme Court make a decision, it's not always an automatic that things happen. All right. On to sources of law, legislative law, and administrative law. Most of our laws that we think of now that come out come from our legislator. They get together, they build, they come up with a bill. Once they come up with the bill, they put it up for a vote, and if it passes, it becomes a law. I hope all of you have probably seen the Schoolhouse Rock video. At some point, I may try to put a link to that in the class just for you to be able to see it. Just because I love it. It's like the coolest thing. I remember being a young man and a young child, and that's how I learned what bills and laws and stuff were. But the little bill dancing around until it became a law. But once the legislator does that, they look at a societal problem, they form a law to address it, and they pass it. It then goes to the president for it to be signed. That is legislative law. Administrative law is law that an administrative agencies such as OSHA, your health department, the IRS, the different agencies that regulate parts of society and what we do, they have their own bodies of law. They work as quasi governments. They have a quasi executive, quasi legislative, quasi judicial branch, which means it looks just like it, acts just like it, but it's not really it. All right. Then we have public private law, a little bit more into that. Public law applies to everyone. Private law is binding on the parties, just those specific parties. There's our civil and criminal again. And this is a hierarchy of law. Hierarchies are fun to look at because a lot of times we do not consider them in things like law. So U.S. Constitution is your highest law. Then we have treaties and federal statutes on the same level. Then administrative law, it comes from federal government. Common law, it comes from the federal government, federal courts, and then your state constitutions, your state statutes, your state administrative law, and state common law. Everything on there has to answer to the step above it. You could pull out the state part, put it over here with federal administrative law, and probably not be too out of whack there. It would all fit. That's a true legal term, whack, out of whack. But you can put those two side by side and it still has to line up. Any of that has to line up with the Constitution. If it does not, then it is not a law. All right, legal analysis. When we look at, you're going to be looking at different pieces of law and cases and stuff that'll be in the book. You'll be looking at your case studies, which will address something that a corporation or a business or a group of people are doing that may not be completely legal. And you'll have to analyze it based upon the law, analyze it based upon ethical standards, those type of things. So when you do that, you need to look at decisions of state trial courts. They're not normally reported or published. Sometimes you have those, you have state reporters, but normally reporters, when you see, they don't do it much anymore, but used to all the law commercials, the lawyer would stand in front of a giant bookcase that had all these beautifully bound books. Those are called court reporters. And inside each of those would be list of cases and cases and cases. Most of that is contained in a system called LexisNexis now. There is a version of that that schools can get that is called Lexis Uni or Uni Nexus. That's used, gives you the same access to it, but you can type in a subject of a court case and it'll pull up court cases that match that. And you can see it. Those reports and decisions of state courts or appeals are published in consecutively numbered volumes. How those volumes are set up, we're not going to get into how you would cite those and things because you're not going to be using those too much. There is a special way that you cite legal documents, no matter if you're using APA or whatever. Most of them will refer back to what's called blue book citation. That is how law is cited. You're not going to have to do that. I would not do that to you. It's very in depth, very time consuming, and there's not a program that does it for you. Court decisions are found in those official ones like for the states, and that kind of does it for that one. All right. So that is an introduction to law. It's a fast, quick, just introduction. That's law. Has those pieces to it. It is meant to apply to everyone. We all know there are people who believe they're above the law, and we know there are some at times that are treated as if they're above the law. That is unfortunate, but it is part of society, and it's up to the people to make the change. What you want to look at with this, and as you're reading through chapter 2, keep in mind if it talks about certain terms or the way that laws are applied to the citizens and how it applies. A lot of the questions are based in that you'll see on the quiz. Also learn this because the little pieces that you pick up here will help you as we go forward to build and help you with the case studies and a few pieces like that. So the 2 videos, by the time this gets posted, the 2 videos that should be posted will be an APA citation video plus this first lecture. So if you have any questions on anything that you see come out, this will all come out on Monday this week. So today is the 13th, so it'll come out today on the 13th. Everything will be online and Canvas. If you have any questions, please reach out to me. Don't be afraid to ask. We're going to get rolling here now. And so we have that first week, just 2 small assignments, but now it's going to start building. You have all your assignments that are in Cengage. In MindTap, you have all of your assignments that are assigned in Canvas. Make sure you're staying on top of those. If something happens, you feel yourself getting behind, please reach out to me so we can decide what to do there. We need to work together. If you get behind, I'll work with you. Just I need to know it because when I put in grades in, all I see is a blank space. And if I see enough of those, I'm going to send you an email and see, hey, what's up, what's going on. So make sure that you, if you get behind and there's, you need time, you need whatever, reach out to me so I can work with you on that. So until the next video, and you'll hear me say this all the time, stay safe and study hard.